The courtroom smelled like old paper and floor wax, sharp, dry, and a little tired. Sunlight cut through the tall windows in dusty beams, landing on rows of wooden benches that creaked whenever someone shifted. It was just another Tuesday morning in County Courtroom 3, the kind of place where most cases lasted less than 5 minutes and nobody expected anything unusual to happen. Then he walked in. He looked like he'd just stepped out of high school. Hoodie pulled up slightly, sneakers scuffed at the toes, hands tucked in his pockets like he was waiting for a bus, not standing before a judge. The bailiff gave him a once-over and pointed to the defendant's table without saying a word. A few people in the gallery exchanged glances. One woman whispered to her friend, "Is that even legal?" He looked 16, but he wasn't 16, and he wasn't there by accident. Up on the bench, the judge adjusted his glasses and flipped open the file. Traffic violation. Failure to signal a lane change. Routine. He'd handled 3 of these already that morning. "You represent yourself?" The judge asked, voice flat. The young man nodded. "Yes, Your Honor, no lawyer. No parent, no paperwork beyond the ticket." The judge sighed, already mentally moving on to the next case. "You understand the charge?" "I do. Any reason I shouldn't just assess the standard fine?" There was a pause, just long enough to feel odd. Most people would have mumbled an apology or asked for more time, but this one stood straighter, shoulders relaxed, eyes steady. "Actually, Your Honor," he said, voice calm but clear, "I'd like to challenge the legality of the stop itself." A few heads turned. Even the court reporter looked up from her machine. The judge blinked. "On what grounds?" "The officer claimed I failed to signal," the young man said. "But according to State Code 424107, a signal is only required if the movement affects another vehicle. There was no other car within 200 feet. The dashcam footage, already submitted as Exhibit A, confirms that." Silence. The judge stared. The prosecutor, who'd been scrolling on his phone, froze mid-swipe. Someone in the back coughed nervously, because here's the thing. Nobody talks like that in traffic court, not unless they've spent years studying law. And this kid didn't just quote the statute, he cited the exact section, referenced evidence already in the file, and did it without notes, without hesitation. The judge leaned forward slightly. "Are you in law school?" "I graduated last spring," the young man said simply. "Passed the bar in July." Now the room really stirred. Whispers spread like ripples in a pond. The bailiff crossed his arms, eyebrows raised. The prosecutor finally sat up straight and started flipping through his own file, suddenly very interested. But the judge wasn't convinced. "If you're a licensed attorney, why are you dressed like that? And why didn't you identify yourself at the start?" A small smile flickered at the corner of the young man's mouth. "I wanted to see what would happen. That's when things got strange." He explained calmly, respectfully, that he'd been conducting an informal study. Not for a class, not for a grade, but because he'd noticed something troubling. People who looked young, poor, or out of place often got treated differently in court, even for the same offenses. Sometimes it was a harsher tone. Sometimes it was a quicker fine. Sometimes it was just the way they were looked at, like they didn't belong. So he decided to test it. He'd worn the same clothes to 3 different courthouses over the past month. Same haircut, same quiet demeanor. In 2 of them, he'd been fined immediately, no questions asked. In the 3rd, the judge had actually told him to go home and let your parents handle this. But here, in this courtroom, he'd waited. He wanted to see how far it would go before someone questioned the fairness of it all. "I didn't break any rules," he said. "I filed the proper motion to appear pro se. I cited the law correctly. But the moment I walked in, I was judged, not on the facts, but on how I looked." The judge sat back. His expression shifted from skepticism to something quieter, thoughtful, maybe even uneasy. He glanced at the prosecutor, who just shrugged, clearly as surprised as everyone else. "You're telling me," the judge said slowly, "that you staged a traffic stop to make a point?" "Not staged," the young man corrected gently. "I drove exactly as I always do. The officer chose to pull me over. I simply didn't correct his assumption about who I was. He wasn't angry. He wasn't showing off. He just wanted the truth to be seen." Then he did something unexpected. He reached into his backpack, not fast, not threatening, and pulled out a thin folder. Inside were printouts, court transcripts from other cases, Photos of young defendants being treated dismissively, even a timeline of his own courtroom visits with notes on how long each hearing lasted and what was said. "I'm not here to embarrass anyone," he added. "I'm here because the system only works if it treats everyone the same, no matter what they wear, how old they look, or whether they have a lawyer beside them." The judge was silent for a long time. The clock on the wall ticked loudly. Outside, a siren passed in the distance. The air felt heavier, like the room itself was holding its breath. Finally, the judge spoke. "Fine is dismissed," he said. "Case closed," but he didn't bang the gavel. Not yet. Instead, he looked directly at the young man and asked, "What's your name?" The young man hesitated just for a second. Then he said, "It doesn't matter. What matters is what happens next." And with that, he gathered his things, nodded politely, and walked out the same way he came in, quiet, unassuming, and completely unforgettable. People in the gallery didn't move right away. They just sat there stunned as if they'd just witnessed something rare, something real. The prosecutor closed his file slowly. The bailiff shook his head and muttered, "Well, I'll be—" Up on the bench, the judge stared at the empty defendant's table. For the first time in years, he didn't rush to call the next case. He just sat there thinking, because sometimes truth doesn't come in a suit and tie. Sometimes it walks in wearing a hoodie and changes everything. The courtroom didn't empty right away. People lingered, whispering in low voices, glancing toward the door the young man had just walked through. Even the judge stayed seated, fingers tapping lightly on the bench, his expression unreadable. But before anyone could leave, the bailiff stepped forward and said something that surprised everyone. "He's coming back." Sure enough, within minutes the same young man returned, but this time, he wasn't alone. A woman in a crisp blazer walked beside him, holding a slim briefcase. She wasn't flashy, but her posture said she belonged in courtrooms far bigger than this one. She nodded respectfully to the judge and handed him a sealed envelope. Inside were documents that would turn the morning's strange encounter into something far more serious. The judge opened the first page slowly. It was a letter from the State Bar Association, confirming the young man's license to practice law, granted just 3 months earlier, after he'd passed the bar exam with one of the highest scores in the state's history. Attached were transcripts from a top-tier law school, letters of recommendation from professors and judges, and even a copy of a legal journal article he'd co-authored on procedural fairness in municipal courts. But the most striking thing wasn't the paperwork, it was the tone. Everything was factual, calm, and respectful. There was no accusation, no drama, just evidence. "I didn't come here to trick anyone," the young man said when the judge looked up. "I came because I saw a pattern, and patterns matter." He explained that his project wasn't some prank or stunt. It started months ago, after he volunteered at a legal aid clinic. He'd watched teenagers, delivery drivers, and low-income folks get shuffled through court like they were invisible. Not because they'd done anything wrong, but because they didn't look like real defendants, whatever that meant. No suits, no briefcases, no confident handshake with a lawyer. So he decided to test it himself. He'd worn the same outfit, a plain gray hoodie, dark jeans, and worn sneakers, to 5 different courthouses over 6 weeks. In each one, he committed a minor, non-hazardous traffic infraction, failing to signal, rolling through a stop sign, parking just outside the lines. All technically violations, yes, but the kind officers often let slide with a warning, especially if you're polite and look respectable. But every single time he showed up in that hoodie, he got a ticket. And when he appeared in court looking like that, he was treated like a nuisance, not a citizen with rights. In 3 of those courts, he said, I was fined within 2 minutes. No chance to speak. No review of evidence. One judge told me, if you can't afford a lawyer, maybe you shouldn't drive. The gallery fell silent again. Even the court clerk stopped typing. But here, he continued, glancing around, something different happened. You listened. Even when you were skeptical, you gave me space to explain. That's why I came back, to show you this wasn't about you. It's about the system. He then pulled out a small tablet and, with the judge's permission, played a short video. It showed clips from his visits, security camera footage from courthouse hallways, audio from waiting areas, even snippets of his own hearings. In one clip, a public defender sighed and said, "Another kid in a hoodie, good luck getting a fair shake." In another, a clerk muttered, "They never show up anyway," before tossing a file onto a growing stack. It wasn't edited for drama. There were no dramatic music cues or slow-motion shots, just real moments captured quietly, showing how easily bias slips in, not through shouting or malice, but through tired routines and unspoken assumptions. The prosecutor, who'd been quiet this whole time, finally spoke up. "So, you recorded all this without telling anyone?" "I didn't record private conversations," the young man replied. "Only public spaces, hallways, waiting rooms, open court sessions. Everything complies with state recording laws. I even got written consent from the two clerks you see in the footage." He wasn't defensive. He was thorough. And that made it harder to dismiss him as just another angry kid with a grudge. The judge leaned back, rubbing his temples. "You understand how this looks, right? Walking in here pretending to be just another teenager. It could have backfired badly." "I know," the young man said. "And if I'd been wrong, if the system had treated me fairly from the start, none of this would have been necessary. But it didn't, and someone had to notice." Then came the most surprising part. He wasn't asking for money. He wasn't demanding an apology. He wasn't even suing anyone. Instead, he handed the judge a one-page proposal, a pilot program where law students, dressed in everyday clothes, could observe local court proceedings and document how defendants are treated based on appearance, age, or speech, not to shame anyone, but to help train judges, clerks, and officers to recognize unconscious habits. "It's not about blame," he said. "It's about awareness. Because fairness shouldn't depend on whether you look like you belong." The judge read the proposal twice. Then he looked up. "You really think this will change anything?" "I don't know," the young man admitted. "But if we never look closely, we'll never know what's broken." By now, reporters who'd been covering a neighboring case had gathered near the doorway. One raised a hand and asked, "Are you going public with this?" He shook his head. "Not unless it helps the cause. This isn't about me. It's about the people who don't have the chance to come back with a bar card and say, 'Wait, that wasn't fair.' Most of them just pay the fine and walk away, thinking the system's rigged, and maybe it is a little, in ways we don't even see." His words hung in the air, simple but heavy. Later that afternoon, the courthouse buzzed with quiet conversation. Clerks double-checked their notes. Public defenders talked about how often they'd seen similar things. Even the bailiff admitted, "I've seen kids get talked down to just because they wore a baseball cap." And the judge? He called an emergency meeting with the court administrator. By the end of the week, they had agreed to review all traffic court procedures, add a short training module on implicit bias, and most unexpectedly, invite the young man to present his findings to the entire judicial district. But he didn't show up in a suit. He came in the same hoodie, because the point wasn't to prove he was special. It was to prove that everyone deserves to be seen exactly as they are. The story should have ended there. A surprising courtroom moment, a lesson learned, maybe a quiet policy tweak behind the scenes. But it didn't, because once the truth gets out, it doesn't stay quiet for long. Within 48 hours, a local news station ran a short segment. "Teen defendant stuns court, turns out he's a licensed attorney." It wasn't sensational. No dramatic music, no flashing headlines, just grainy courthouse footage and a calm voiceover explaining what happened. But people shared it, first in legal circles, then on social media, then across national news desks. Suddenly, everyone wanted to know, who was this person? How did someone so young pass the bar? And more importantly, was what he said actually true? That's when things shifted from curiosity to conversation. Public defenders started speaking up. Not in press conferences, but in staff meetings, online forums, even over coffee in courthouse cafeterias. "He's not wrong," one said quietly during a training session. "I've seen judges cut off clients the second they say or wear a hoodie. Like they're wasting time just by being there." A retired clerk from another county emailed the court administrator, sharing her own notes from 20 years on the job. "We used to joke about the hoodie crew, kids we assumed wouldn't show up or couldn't pay. But some of them were working 2 jobs and just couldn't afford a suit." Even the police union issued a cautious statement. "While we support lawful enforcement, we recognize that perception can influence outcomes. And we're open to reviewing training protocols." But not everyone was on board. Some judges called the whole thing a publicity stunt. One wrote an op-ed arguing that courts can't cater to appearances. and that respect for the law starts with how you present yourself. Others worried it would encourage people to game the system by dressing down on purpose. The young man didn't respond to any of it. He stayed off TV, turned down podcast invites, and didn't post anything online. But his silence spoke louder than any interview could. Instead, he did something quieter and more powerful. He released his full research, anonymous, clean, and backed by data. Not just his own experiences, but hundreds of hours of observation across 10 courthouses. He tracked how long hearings lasted based on what defendants wore. He noted how often judges interrupted people in casual clothes versus those in business attire. He even recorded the tone of voice used by clerks when calling names from the docket. The numbers didn't lie. Defendants in hoodies, baseball caps, or worn-out jackets were interrupted 68% more often. Their cases averaged 2.3 minutes, less than half the time given to those in suits or formal wear. And they were 3.1 times more likely to receive the maximum fine without discussion. It wasn't about guilt or innocence. It was about dignity. When legal scholars saw the data, they took notice. A professor at a major university called it one of the clearest real-world demonstrations of implicit bias in the justice system we've seen in years. Law schools began using it in ethics classes. One even built a simulation where students role-played as judges, then reviewed their own decisions against the data. Back in the original courthouse, things started to change, slowly but surely. New signs went up near the entrance. All are welcome. Dress does not affect your rights. Court clerks received refresher training on neutral language, and judges agreed to a simple rule. Before issuing any fine in traffic court, they'd ask one question: "Do you have anything you'd like to say?" And actually wait for an answer. The judge from that first hearing became an unexpected advocate. He didn't make grand speeches, but in meetings with other judges he'd say, "I thought I was being fair." But fairness isn't just about the law. It's about how you make someone feel when they walk in that room. One afternoon, a teenager showed up for a parking ticket wearing a faded band t-shirt and ripped jeans. The judge didn't sigh, didn't glance at the clock, just looked him in the eye and said, "Tell me what happened." The kid, stunned, stammered through his explanation that his mom's car broke down. He was late for his shift at the grocery store, and he'd parked in a loading zone for just 3 minutes. The judge listened. Then he reduced the fine to $25 and told him, "Next time, call the store. They'll usually hold your spot." The kid left with his head a little higher. That's when people realized this wasn't just about one courtroom or one young lawyer. It was about restoring trust in a system that, for too many, had started to feel cold, distant, and unfair. Even the prosecutor from that first day changed his approach. He started reviewing dashcam footage before every traffic case, not just assuming the officer was right. "If we're going to fine someone," he told a colleague, "we better be sure it's right." And then came the most unexpected ripple. A group of high school students in a nearby town started a Know Your Rights club. They handed out simple flyers explaining what to do if you're pulled over, how to request a court interpreter, and what your options are if you can't afford a lawyer. They even organized a mock courtroom day, where students dressed however they wanted and practiced speaking up for themselves. One girl, barely 15, said afterward, "I used to think court was only for bad people. Now I know it's for everyone, and we all deserve to be heard." No one could have predicted that a single traffic ticket would lead to all this. But sometimes it only takes one person to ask why, and another to finally listen. The young man never took credit. He kept working quietly, helping tenants facing eviction, advising small business owners on permits, even tutoring kids in civics after school. When asked why he didn't chase fame or a big law firm job, he just said, "The law isn't a trophy. It's a tool. And tools are meant to be used, not put on a shelf." By the end of the month, the State Judicial Council announced a new pilot program inspired by his work. Fair treatment observers, trained volunteers who'd sit in courtrooms not to judge, but to ensure everyone, no matter how they looked, got a real chance to speak. And in a small office downtown, a framed photo appeared on a clerk's desk. It showed a crowded courtroom, sunlight through the windows, and one young person in a gray hoodie, standing tall, speaking truth, and changing everything without raising his voice. The story kept growing. but the person at the center of it stayed out of sight. While news outlets debated the ethics of his courtroom appearance and legal blogs dissected his research, he was busy doing the kind of work most people never see. Sitting in cramped community centers, helping elderly neighbors understand eviction notices, or walking high school students through their first legal aid applications. He didn't wear a suit, didn't carry a fancy briefcase, just a worn backpack, a notebook full of scribbled questions, and a quiet belief that the law should serve everyone, not just those who know how to play the game. But the world wasn't ready to let the story go. A major national newspaper ran a feature titled, "The Hoodie Lawyer: What One Young Attorney Revealed About Justice in America." It wasn't flashy. No dramatic headlines or staged photos. Just honest reporting. Interviews with clerks, judges, and everyday people who'd felt invisible in court. The piece ended with a quote from him. "Fairness isn't something you earn by dressing a certain way. It's something you're owed just by being human." That line went viral. Schools started using it in civics classes. Community organizers printed it on flyers. Even a few city council meetings opened with it as a reminder before voting on local ordinances. But the attention also brought pressure. Big law firms reached out with six-figure offers. Talk shows begged for an interview. A documentary crew showed up at the courthouse, hoping to film a follow-up. He turned them all down, not out of pride, but because he knew the moment this became about him, it would stop being about the people who needed help the most. "If I start giving speeches," he told a friend, "I'll stop listening. And listening is where real change starts." Still, his impact couldn't be ignored. The State Judicial Council, after weeks of internal discussion, announced a formal review of bias in lower courts. They didn't just look at clothing. They examined how language, tone, and even seating arrangements might make someone feel unwelcome. One recommendation stood out. All municipal court staff would now receive annual training on implicit bias, developed in partnership with legal aid groups and community advocates. Even more surprising? The police department in the county where it all began agreed to update its traffic stop protocols. Officers would now be required to note in their reports whether other vehicles were present during a signaling violation. Exactly the detail the young man had cited in court. It wasn't a huge change, but it was a start. And it came from someone who hadn't shouted, sued, or demanded headlines, just showed up, spoke clearly, and asked for fairness. Meanwhile, law schools took notice in a different way. Several deans reached out, not to recruit him for a faculty position, but to ask how they could teach students to think like he did, not just memorizing statutes, but understanding how the law feels to the people it affects. One school even created a new course called Law in Everyday Life, where students spent half their time in courtrooms observing, the other half in neighborhoods talking to residents about their experiences with the justice system. A few professors admitted, quietly, that they'd been teaching law like it existed in a vacuum. Clean, logical, perfect. But real life isn't like that. Real life is messy, emotional, and shaped by things like how tired a judge is, how rushed a clerk feels, or whether someone looks like they belong. And that's exactly what the young man had shown. Back in the community, something quieter but just as powerful was happening. People who'd once avoided court, afraid they'd be laughed at, ignored, or fined no matter what, started showing up again. Not because the system was perfect, but because they'd heard the story. They knew someone like them had stood in that room and been heard, and if it could happen once, maybe it could happen again. One woman, a single mom working nights at a diner, came in for a noise complaint filed by her landlord. She wore her work uniform, black pants, white shirt, name tag still pinned on. The judge didn't sigh, didn't glance at the clock, just asked, "What's your side of this?" She explained that her toddler had a fever that night, crying until 2 a.m., and she'd been trying to soothe him while her neighbor banged on the wall. The judge listened, reviewed the complaint, and dismissed it with a note. Family emergencies aren't violations. She left crying, not from fear, but relief. That's the thing no one talked about enough. Dignity matters, not just in big rulings or landmark cases, but in small moments, when someone looks you in the eye and says, "I hear you." As the months passed, the young man kept working behind the scenes. He helped draft a plain language guide to traffic court rights, printed in English, Spanish, and 3 other languages, handed out at DMVs and community centers. He advised a city council on how to simplify legal forms so people wouldn't need a lawyer just to fill out a parking appeal. And he quietly mentored a group of first-generation college students interested in law, telling them, "You don't have to sound like a textbook to be smart. You just have to care enough to show up." He never took credit for the changes happening around him, but those changes were real. Courthouses started posting clear signs about rights and procedures. Some even added community liaison roles, staff trained to help nervous or confused visitors navigate the system. And in one small town, a judge began opening each morning session with a simple sentence: "Everyone here matters. Let's treat each other like it." None of it was perfect. Bias doesn't vanish overnight. But the conversation had shifted from, "That's just how it is," to, "What can we do better?" And through it all, the young man stayed focused on what mattered. Not fame, not praise, but people. Because in the end, the law isn't about gavels, robes, or fancy titles. It's about whether a tired parent, a scared teenager, or a quiet kid in a hoodie can walk into a room and know, without a doubt, that they'll be treated like they belong. That's the legacy no headline could capture, but it's the one that lasts. Time passed as it always does. Seasons changed. Leaves fell, snow came and went, and spring returned with its usual quiet promise of new beginnings. The courthouse where it all started looked much the same from the outside. Same stone steps, same brass door handles worn smooth by decades of hands. But inside, something had shifted. Not in a loud or flashy way, but in the small, steady choices people made every day. The judge who once fined a teenager without a second thought now made it a habit to pause before speaking. He'd look up from his notes, make eye contact, and say, "Take your time." It wasn't part of any official policy. It was just something he'd started doing after that morning. The morning he realized fairness isn't just about the law on paper, but how it feels in the room, and that feeling began to spread across the state. Courthouses introduced community observation days, where locals could sit in on hearings, not as defendants but as witnesses to how justice is served. Some came out of curiosity. Others came because they'd been treated unfairly before and wanted to see if things had changed. Most left surprised, not by dramatic rulings, but by the simple act of being acknowledged. A nod, a patient explanation, a clerk who didn't sigh when asked to repeat instructions. One high school even partnered with the local court to create a youth legal ambassador program. Students trained in basic rights, learned how to read court documents, and helped neighbors fill out forms. They didn't wear suits. Some wore hoodies, and no one batted an eye, because the message had finally sunk in. How you look doesn't determine your worth in the eyes of the law. The young man who started it all. He never claimed credit. He kept working quietly, sometimes in legal aid offices, sometimes at kitchen tables, sometimes over the phone with someone who just needed to know their rights. He turned down book deals, speaking tours, and even a chance to clerk for a federal judge. Not because he didn't care about influence, but because he believed real change happens in the everyday moments, when a scared parent learns they can ask for more time, or a teenager realizes they don't need a lawyer to be heard. He did, however, agree to one thing: helping design a new training module for new judges. It wasn't full of legal jargon or theoretical debates. Instead, it included real audio clips from courtrooms, some respectful, some dismissive, and asked trainees to reflect. How would you feel if this were you? It also included a simple exercise: spend one morning sitting in the public gallery just watching. Not judging, just seeing. One judge in training later wrote in her notes, "I never realized how much silence speaks. When someone doesn't get a chance to finish their sentence, it's not just rude, it's a kind of erasure." That's the word that kept coming up. Erasure. The quiet act of making someone feel like they don't matter, and the quiet act of undoing it, by listening, by pausing, by treating every person like they belong. Years later, a young woman walked into County Courtroom 3 for a parking ticket. She wore jeans, a faded band t-shirt, and sneakers with holes in the toes. She'd stayed up all night with a sick child and hadn't had time to change. Her hands shook as she approached the bench, but the judge didn't frown, didn't glance at the clock, just looked at her and said, "Good morning."
What happened?
She explained, haltingly at first, then with more confidence, that her car had stalled near a fire hydrant and she'd only been gone 3 minutes while she ran into a pharmacy for medicine. She pulled out a receipt as proof. The judge reviewed it, nodded, and said, "Emergencies happen. Case dismissed. She stood there for a second, stunned. Then she whispered, "Thank you." "No," the judge said gently. "Thank you for showing up." As she walked out, she passed a poster on the wall. It showed a simple quote in plain letters. "Justice isn't earned by how you dress. It's owed to you by how you're treated." She didn't know who wrote it, but she felt it. That's the thing about real change. It doesn't roar. It settles in like morning light, soft but steady. It shows up in the way a clerk smiles when you ask a question. In the extra minute a judge takes to explain a ruling. In the fact that no one bats an eye when a teenager in a hoodie stands up and says, "I'd like to speak." The young man who sparked it all is still out there, somewhere. Maybe helping a tenant fight an unfair eviction. Maybe tutoring a kid who dreams of law school but doesn't know where to start. He doesn't need a spotlight. His work speaks for itself, and the system? It's still imperfect. Bias doesn't vanish overnight. But now there's a shared understanding, a quiet agreement that everyone deserves to walk into a courtroom and feel like they belong. Not because they're perfect or polished or powerful, but simply because they're human. In the end, that's what justice should be. Not a performance for the well-dressed, but a promise to everyone. And sometimes it takes one person, wearing nothing but a hoodie and courage, to remind us of that promise. The gavel may fall, the files may close, but the echo of that morning lives on, in every fair hearing, every patient word, every moment someone chooses to see the person, not just the close, and that's a legacy no headline can capture, but everyone can feel.